This is now the beginning of part 2 of the video regarding the CFPB and Nationwide Biweekly Administration and myself and my family and us being destroyed by the CFPB. So part 2, after the DAs lost their prorater scam and the DBO bailed on them, and they then joined together with the Bureau of Real Estate, where we did have our license since 2004, to get them to try to come after us. And then we finally had to file for injunctive and declaratory relief, so we had to file a federal court lawsuit on October 2nd, 2014 to protect ourselves from their threats of filing a suit. So now the CFPB is brought in and the CID process begins, which is a civil investigative demand process where you have to turn over everything. And it's a difficult and expensive process. And then also this is the part about them taking my deposition, the CFPB. So eventually we learned that the DAs had been in contact with the San Francisco office of the CFPB no later than in the spring of 2014. We learned this because in June of 2014, the CFPB issued its first civil investigative demand, or CID. About 1 week later, the DAs and the CFPB agreed to provide access of NBA's documents to each other. This agreement was dated June 19th, 2014. This was only 1 week after the CID was issued on June 14th, 2014. Thereafter, a common interest agreement was signed in July 2014 between the DAs and the CFPB. This CID process is supposed to be highly confidential, but obviously was not. NBA immediately cooperated with the CFPB to provide all documents requested within a very short time frame. NBA had to hire an attorney to organize the discovery and documents provided, and to hire an IT company to provide the documents in the form mandated by the CFPB at a cost of around $130,000 for outside costs. It is noteworthy that NBA did not seek any court intervention regarding this CID, which we probably should have. Because again, we didn't know how all these items were being connected together at this time. So from June 2014 to about early 2015, NBA worked hard to get the CFPB what it needed. Then it came time for the depositions. CFPB took NBA's founder's deposition, myself, Daniel Lipsky, what is telling about this is that Mr. Lipsky said, myself, that if the CFPB would point out anything about which it had concerns, that I would work together with the CFPB to figure out a good way to make changes and address any concerns. This was said in earnest both on the record and off the record. We've always operated that way. At the deposition, Mr. Lipsky and the CFPB attorneys talked about how many jurisdictions with which NBA must deal, and that each state has their own mindset interpreting things differently from one another as you try to please everyone at the same time. Even so, NBA had been able to work cooperatively with many different states with different ideas about what they wanted. So with the CFPB, NBA thought it was just a matter of just finding out what the CFPB thought was a concern and what manner CFPB thought this concern could be resolved. Especially knowing that Richard Cordray is the director of the CFPB, and we already had 2 years of scrutiny with Richard Cordray with the Ohio Attorney General's office. So we're thinking this should be very clean and easy with what's already been done years ago and how we've complied with that. But you're going to find out that they came after us for the same things that had already been agreed upon with the Ohio AG, Richard Cordray. NBA was very willing to resolve these concerns cooperatively. That is what NBA expected, because we do not know what each person or agency is thinking. It's difficult for NBA to know what the persons within an agency are thinking unless they inform us. I mean, how is that not correct? Just morally correct to inform a person or company what the concerns are instead of keeping them secret. What are the intentions at that point? Once they inform NBA, other times in the past with other states, we have always been able to, in the past, to accurately and effectively resolve their concern. NBA has a proven track record of resolving any concerns that a state agency may have had over the years, over many years. Being licensed in over 40 states and having about 15 on-site examinations, we had definitely paid our dues and proven that we will work hard to resolve any issue or concern. Our intent has always been to do the right thing for our customers. Even through this process, even some of the state agencies couldn't understand why the CFPB was doing what they were doing, because these state agencies had worked with us for years. And so they knew exactly how we operated. And even they were like, why are they doing this? But they had no ability to intervene as just a state agency. Unfortunately, following the depositions, while NBA was waiting and expecting to hear from the CFPB what, if any, concerns existed, apparently CFPB was preparing to and did file a lawsuit. I believe they already had that as their game plan to file the lawsuit no matter what, because the DAs needed their power. So in a way, my opinion is that the CFPB weaponized the DAs with their power. The DAs used the CFPB to be their, I don't know, hitman, whatever phrase you could associate with that situation, that relationship. It is the truth of the situation that CFPB never stated before the lawsuit what they wanted. How could NBA have fixed something they were not informed about at all? And we asked over and over, what are your concerns? What can we do? Are you aware of the agreed order of voluntary compliance with the Attorney General, Ohio, when Cordray was there? Does Cordray know about this as the director of CFPB? Is he aware of what you guys are doing? Can there be a conversation to discuss this? This is a serious matter. So May 11th, 2015, CFPB files their lawsuit. What a terrible day May 11th, 2015 was. Everyone here in Xenia, Ohio remembers the day of devastation. We found out through a press release that our attorney saw, who then called NBA. We did not even get a phone call from the CFPB attorney until after the press release had already been sent out all over the internet. And just so you understand, that is a chess move. There is a reason they do that. You're going to find out in another situation with another Biweekly company, they didn't do that. They did a press release after everything got settled. But they did this right out the gate because they knew the devastation that that press release would have and what it would imply when nothing had been proven whatsoever. So an NBA was now in the frantic mode of asking the CFPB, what are the changes you want in our direct mail letter, or what it wants? We could never understand why CFPB didn't work with us to resolve their concerns, especially after NBA had worked with the Ohio Attorney General's office for 2 years to outline what NBA was specifically required to do for its scripts, marketing letters, materials, processes, everything in great detail. And NBA has honored that agreement. So once we learned more about the DAs, however, things became clear. Did it help the DAs in their lawsuit with NBA to have the CFPB file its own lawsuit against NBA? If so, did the DAs mislead CFPB into believing that NBA would not work with the CFPB, which both CFPB and DAs knew were false? The October 2014 lawsuit against the DAs had progressed to the Ninth Circuit of Appeals by March of 2015. This was about the same time the CFPB was ending its CID process with depositions. The DAs had a brief due in the Ninth Circuit on May 15th, 2015. So were the DAs in a time crunch to get the CFPB lawsuit filed before their due date of May 15th? The CFPB lawsuit was filed on May 11th, 4 days before. Did CFPB follow its own schedule, or did CFPB follow a schedule critical to the DAs? Did the CFPB lawsuit on May 11th allow the DAs to get their sign-offs from their offices to file a state court lawsuit for large civil penalties against NBA to be filed on May 15th, to relieve them of their obligation to file a response brief on the merits of their lies, of phony complaints? So instead, the DAs moved to dismiss the Ninth Circuit case on the grounds of abstention rather than filing their brief. Because now the DAs had the CFPB's case and all the publicity by CFPB press release to tie their state lawsuit to. They tied it to the CFPB lawsuit, which carried much more power. Did CFPB file their pre-planned no-notice lawsuit just to help the DAs? Common sense. Was this just a coincidence of timing within days? 4 days between the two lawsuits and just in time to meet the DA's deadline with the Ninth Circuit? How could this happen without intent? Now, June 2015, all 4 banks send NBA termination notices. To provide our service to our customers, we have to debit their account, and then remit payments to the lender. Well, that's through the ACH services of a bank. And we worked with 4 of the largest banks who we had great relationships with. They were all trying to take of our business away from the other bank. So we had it divided up 25% within each 4 bank of hundreds of millions of dollars in processing to their accounts. Over $1 billion a year. And I remember some of the banks saying, hey, we want all your business, give it to us. They wanted us to bump out each other, okay? So about a month later, NBA's 4 banks, Bank of America, US Bank, TD Bank, and BMO Harris, that held and processed billions in loan payments for NBA's 135,000 active customers, began to say they were going to terminate the NBA accounts. There's been no hearing. Nothing proven nothing. But there's a press release. And also, the CFPB oversees and regulates these banks. These bank accounts were essential to the 135,000 NBA customers using the ACH electronic banking services provided by the banks. NBA was working frantically with the banks to stop this combined termination effort by all 4 of the NBA banks. As we learned later, the banks were not evaluating NBA in making this decision. They weren't evaluating us. Even what the CFPB claimed in their lawsuit had nothing to do with concerns about processing of payments. So the active customers on the program, there was no concerns about customer funds. It was all simply about marketing. That's it. So we told the banks, there's no risk. They're not claiming any risk concerns or allegations about the processing that we do with you banks for these customers. The marketing has nothing to do with the banks. But NBA learned the truth from 2 representatives of US Bank. to employees in a June 15, 2015 call to an NBA employee describing as being just between the three of us phone call that is recorded, that they would have to terminate the relationship with NBA. Specifically, the representatives with U.S. Bank noted that the CFPB has long arms, unlimited resources, and is not even regulated by the federal government, so it can do whatever it wants. They noted that they have had a lot of bad experiences with the CFPB, and whenever they see the CFPB, they turn around and run the other way. Once bitten, twice shy. That's what they said. Further, the representative specifically noted that Nationwide had always been a good customer, and they felt sick, were their words. They felt sick about terminating the account, emphasizing that this was not a reflection on Nationwide biweekly administration. The lawsuit, or what it was about, didn't matter. The fact that all of the customer funds were and have always been appropriately handled didn't matter. All of NBA state regulators and the CFPB itself agree that there was no risk to customer funds. NBA was confused and didn't understand why all the banks would want to leave at once. We later came to realize that this was the beginning of the Operation Choke Point tactic. You might want to look up Operation Choke Point and do a search as to what that is. Just a brief explanation. Operation Choke Point started in other government agencies and then it ended up in the CFPB. Imagine this agency doesn't like your company, doesn't like your foundation, your ministry, whatever it may be, but they can't do anything legally. So behind the scenes, they talk to the bank that you have your accounts with, your bank, your company accounts with, your foundation accounts with, your ministry, whatever it is. And they tell the bank that they're at risk by having accounts with your organization, just having them. So you end up getting a letter from the bank saying, we are closing your accounts. That's Operation Choke Point. Choking off your accounts. How can any company exist in the United States without a checking account? You can't. You cannot operate all cash business for big companies, small companies, anybody having no checking account. The lawsuit, it didn't matter. It was an Operation Choke Point tactic. I'm sorry, I lost my place. June 29, 2015, CFPB misleads NBA. NBA asked for a special meeting with the CFPB about the bank termination notices. If all of the banks stopped servicing NBA customers at once, the customers would be left without their interest savings program that they chose and they paid for and they wanted. Recognizing the importance of alerting the CFPB to this, NBA requested high-level CFPB enforcement attorneys to attend. Mike Salemi, Deputy Director of Enforcement, and Melanie Hirsch, lead attorney assigned to the case, agreed to meet with NBA counsel in person in Washington, D.C. on June 29, 2015. NBA was told by the CFPB attorneys that the CFPB did not want NBA to go out of business on their watch. That was, in my opinion, a total lie. Total deceptive, deceit to the hilt. Because what they already did. They knew the damage and the harm of their actions would cause. But yet they're saying to our face that they did not want NBA to go out of business on their watch. But the sad fact that we later learned is that the CFPB did not mean what it said, and it appeared to be a lie. When CFPB had the opportunity to do something right after this June 29th meeting, CFPB refused to do anything at all to prevent these banks from terminating services. And 135,000 customers losing their services and their scheduled billions in interest savings off their mortgage loans. And the CFPB offered no alternatives. None. No alternative. Go find another program. What the CFPB attorneys did actually ended up diverting NBA and wasting a lot of time and attorney's fees. CFPB told NBA, let's go ahead and get this settled. So again, CFPB is telling us, let's go ahead and get this settled. Let's get them to waste some time on settlement talks. This made us believe that the CFPB would help the situation with the banks by working expeditiously on a good faith settlement. Another biweekly company called PayMap. I want to explain what happened between the CFPB and PayMap, who was another biweekly company. Shortly after this in-person meeting, CFPB announced a consent judgment with this other company, PayMap, who's owned by Western Union. And they have their own biweekly mortgage program. The CFPB issued a press release regarding this settlement, and the CFPB attorney Melanie Hirsch said that NBA would be well served to remember what happened to PayMap. But again, their press release didn't happen until after everything was settled and agreed on. So Melanie Hirsch throws this threat, I guess, that it serves us well to remember what happened to PayMap. While she may have been referring to the large civil penalty of $33 million, Western Union agreed to pay to CFPB. There was another point NBA later learned. While NBA had no notice whatsoever before the filing of this lawsuit, it turned out that CFPB treated Western Union more favorably than it treated NBA. Spending 1 year in negotiations with Western Union to work out a resolution, in 0 days working out a resolution with NBA. None. They gave us 0 days. And they gave Western Union, who owned PayMap, an entire year before making anything known in a press release. And even then, their press release was, it's been resolved. Ours was allegations of wrongdoing, painted that we were as corrupt as can be. Richard Cordray saying this, who was the one who scrutinized us for 2 years as Ohio AG. PayMap was a company that had never been scrutinized by any government agency, where we had, whereas NBA had spent 2 years being scrutinized by the Ohio Attorney General's office. What does it say that Western Union got much more favorable treatment from CFPB than the Ohio company that had already worked out an agreed entry with the Ohio Attorney General Richard Cordray years prior? What justification is there for providing notice? What justification is there for providing notice of what CFPB wanted changed to a big company like Western Union and skipping any notice to a small company like NBA? Is this selective notice or selective prosecution? CFPB settlement demand. It took from June 29th to early October to get a settlement demand from CFPB. When we finally did, on the eve of a formal mediation, the settlement figure of $60 million was so outrageous for a small company in Xenia, Ohio, and it had no basis in any claim CFPB could articulate how any customer was harmed by a program that saved them from paying interest to their lender. We later came to believe that the settlement talks were just a ruse. From 2002 to 2015, NBA had saved its customers over $3 billion by successfully reducing the original projected finance charges of their mortgage loans, while NBA only charged a small percent of that amount in fees. Where is the customer harm to justify a $60 million settlement demand? In the recent Wells Fargo case that everyone I'm sure knows about, when 1.5 million fraudulent checking accounts were created, CFPB fined Wells Fargo $100 million. This is Wells Fargo and how big they are. And they're trying to demand $60 million from us, and they can't even explain how they came up with the figure. And we're a small little company with 160 employees. November 2015, CFPB mediation in the 4 banks now blackmail NBA. So the mediation went forward despite this out-of-the-sky settlement number, because NBA was desperate to focus on preventing the banks from terminating. The mediator asked that the CFPB sign an agreed comfort type of letter for NBA to provide to the banks, asking them to sit tight while we work the settlement out. The CFP agreed to sign such a letter, but they didn't. NBA pushed to have this letter signed at the mediation while everything was agreed. And it was a comfort letter telling the banks, hey, there's no risk to you. This isn't about customer funds, nothing like that. So you don't need to jump ship on the company like this and cause them to collapse. You can understand at the same time, our program takes revenue, interest earned revenue away from banks. How do banks make their money? Bank fees, but primarily interest charges. So we're not exactly the best of friends. CFPB agreed to sign such a letter, and we pushed to have them sign it while still at the mediation. By the next day, however, the CFPB attorneys refused to sign the letter. I remember telling the attorneys, I'm like, if you don't get this signed while they're here, they're not going to sign it, because I believe they're lying. And I was right. Even the mediator couldn't get them to do anything to provide NBA any type of letter or anything else at all to avoid the termination by these 4 banks of services to 135,000 customers. The customers were not even in the equation in CFPB's analysis. From June 29th through mid-October, NBA made every effort to inform, work with, beg, plead with CFPB to protect the customers from a termination of their services. CFPB rebuffed NBA at every turn, albeit they never just told us that was the plan all along. Once NBA realized that no help was ever going to arrive from CFPB to push back the bank's termination plan, NBA had to act all on its own. The banks wanted NBA to stop requesting ACH services. So they wanted us to initiate the termination, to not send files for continual ACH debiting of the customer's accounts. No doubt because they wanted it to look like NBA was requesting this termination, when of course nothing could be further from the truth. So as the terminations came closer, the banks selected a termination date that occurred during the middle of the month. This is very telling why they chose the middle of the month. The impact of this date was that it provided leverage to the bank to get what they wanted. The leverage point was that by mid-month, the banks would have in the NBA trust accounts with their institutions about half of each customer's monthly mortgage payment, or the first biweekly debit, and we needed the second one to then remit payment to the lender. So if the monthly mortgage payment's $1,000, the biweekly is $500. And sometimes, some months, there's 3 of them that fall within a month's time. So they knew that we had tens of millions of dollars of customer funds in these accounts with their banks. If the bank terminated the account mid-month, this money would need to be returned to the consumer immediately, electronically via ACH, in order for the customer to pay their mortgage at the end of the month. And a lot of these people don't have extra money for multiple mortgage payments. They need that money to make their mortgage payment. The banks used the leverage they created by demanding that if NBA didn't sign the request to terminate ACH services, then the banks were going to use their electronic funds transmittal to immediately return the funds to the consumers for use in paying their I'm sorry, let me back up. If NBA didn't sign the request to terminate ACH services, then the banks were not going to use their electronic funds transmittal to immediately return the funds to the customers for use in paying their mortgage. They weren't. They were going to hold it in the account, because if they closed down the account on us, our system could not request that to be done. So they were going to freeze all that money, customer funds. This was shocking. NBA could not believe that the banks would use the customer funds as leverage and to blackmail NBA into signing a document. In the end, with no other alternative, NBA could not leave 135,000 customers high and dry for paying their mortgage without half of their money. I remember this specifically because I had to make this decision. And I knew what they were doing. They were blackmailing me. They were sacrificing 135,000 customers, tens of millions of their dollars, of their money, and threatening to cause them harm, to manipulate me, to make it look like I was requesting the termination. So NBA, I was forced to protect the customers and give in to the banks by sacrificing myself and my company by signing this forced document so that the customers would be protected and they would be able to make their mortgage payments and receive these funds. The customers had to be notified that the bank's termination had caused all of them to now lose their program. And I knew my company was over. Overnight, it all came to a screeching halt in a single day. What took me so many years and so much work and so many battles to be compliant as I'm learning, as I'm going, trying to always make sure that the attorneys are involved, everything's approved, everything's being done correctly, trying to please everybody in an industry that did not have thorough interpretations. That's why the one state said that they were going to model their agency after our company. I have to turn a light on real quick, sorry. Sorry about that. All right, let me continue. Everything but the house settlement offer. So NBA tried a last-ditch effort to get CFPB to turn around the situation. I myself offered up to CFPB all my assets, money, everything, even my new home that I just built for my wife and kids. This was rejected without even a thought, virtually overnight. We began to realize that this was an execution of NBA, with no plans by the CFPB to settle or to prevent NBA from going out of business on their watch. State regulators can't help. Around this time, same time, NBA asked the states that granted its licenses, about 40 states, to help it turn around the situation with the 4 banks. The states, however, did not regulate any of these 4 banks because CFPB and the OCC regulated them. Therefore, the state agencies had no jurisdiction over these 4 banks. A number of these state agencies, however, expressed that they did not agree with the banks terminating NBA because NBA had a good working relationship with them and a valid license in good standing in their state. This sudden termination had an effect on these state agencies with whom NBA kept in close communication throughout the next months. Unfortunately, there was nothing that these state agencies could do regarding the bank terminations. Nothing was helping because no one with jurisdiction was listening. So finally, the situation was this. Having tried a personal meeting on June 29th, having tried to get a letter in the early October mediation, and having tried to settle financially by offering assets and all the money that I, Daniel Lipsky, had personally, along with NBA. The last thing not yet tried was brought up on the table for consideration. NBA was about to give up hope on any way to get through to the CFPB, which had jurisdiction over all of these 4 banks in order to prevent the bank terminations. And the idea came up was a TV commercial. because we still did not know if Richard Cordray knew what was going on in this huge agency, if it was kept under the radar from him even knowing about it. So we had no way. We were attempting to try to reach him, to get a hold of him, nothing. So the idea of a commercial was born by another organization in Columbus, Ohio, working with the attorneys. I didn't know what to do for sure. They came up with the idea. And so the purpose was to beg Richard Cordray to save NBA. This was the only way left to avoid the situation where the information was not moving up in the CFPB organization to Richard Cordray, who had already scrutinized and vetted NBA as Ohio AG. Of course, NBA could not believe that the director of the CFPB would not want to help avoid the bank terminations and the harm to all the customers. And NBA needed the help. At the time, we didn't know what else to do. We had even tried to ask 40 states in which NBA was licensed to help prevent the banks from terminating NBA's program being licensed in their state. At first, NBA didn't want to do this commercial. But we had tried everything, and there was no other option. This commercial may not have been the right thing to do in the end, but it was the only advice that NBA and myself had not yet taken, all of the efforts having failed. And even at this point, we still didn't know really what the CFPB wanted. We had to guess, which I'm going to get into that in just a minute. When that commercial ran, over 8,400 NBA customers signed the petition to save NBA. Within days. We also understood that many people called the CFPB to verbally express their concerns about what they were doing, because these customers wanted this program. Yet CFPB did not change its course and continued to do nothing to avoid the bank terminations and the harm that would be caused to 135,000 families. CFPB blocks settlement with NBA. From Nationwide's perspective, Nationwide was signaled out and blocked from a settlement 2 times in the past, forcing it into the expensive and time-consuming litigation process. This occurred on November 19, 2015, when the settlement talks initiated on June 29, 2015, were shut down by the Bureau's rejection of the all-cash, virtually all assets that existed, holding to its $31 million settlement demand. This settlement freeze-out occurred 1 week after the Bureau was told about NBA's efforts to reach out to the public via TV in the Columbus market. That asked the Bureau to not let the 4 banks terminate services to 135,000 active customers. Within a week, over 8,000 customers signed an online petition trying to save NBA. Nationwide's concern is being pushed for the TV advertisements that were critical of the Bureau, all of which is protected under free speech of the First Amendment. From our perspective, this looks like an abuse of discretion and abuse of power. We are concerned that our First Amendment rights were violated by the Bureau back in 2015. All of its financial information was provided, and the Bureau's demands for payment of monies was way above the financial assets that the Nationwide parties had available. Yet the Bureau walked away from the settlement table right after the TV commercial and petition had occurred, and the Bureau became aware of it. A source exposes CFPB employees abuse power. After the TV commercial, we were made aware that we were being punished for the TV advertisement that were directed toward the CFPB. All of which is something that we felt we had to do to try to protect our company and our customers, and that we believed was permitted under the First Amendment. Yet CFPB walked away from the settlement table right after they became aware of the TV commercial being aired. We know that we were being singled out and frozen out. We have a reliable source of documented proof of information, a reliable source who is very close associate to Richard Cordray, who informed us that because of the TV commercial and the petition, these employees in the CFPB stated to Richard Cordray that they wanted to make an example of NBA. And that goal was exactly what happened. In November 2015, the banks threatened to harm NBA customers. Meanwhile, NBA was working again and again with the banks to get them not terminate the NBA accounts, but the banks refused to change their position over and over. NBA was forced under duress to sign whatever document the banks demanded because the proverbial gun was to the head of the customer. The banks demanded a signature, and NBA knew it would have been pandemonium with 135 customers late on their payments. Because remember, half of their monthly payment or one biweekly debit would have been tied up at the bank, in the bank accounts that we would not have been able to get access to. These funds would have been tied up in the 4 banks with no way of getting these funds back to the customer in time for them to make their next mortgage payment, which would have been in 2 weeks. The banks were threatening to shut down the ACH service overnight without electronically returning the funds to the customers. Many people needed those funds in order to make their next mortgage payment. In the end, the banks would have been responsible, but NBA was not willing to take that risk. We could have easily proven that the banks caused the harm, but I just couldn't do that. I couldn't just point the finger, even though it was accurate. I had to protect the customer. NBA stepped in front and took the bullet for the benefit of the customers and did what it had to do to make sure the customers were protected. So Daniel Lipsky and myself felt he had no option other than to put the customers first and do whatever the banks demanded as ransom to protect the customers. Without CFPB to act as a cop, the banks ran away with their power and NBA had nothing left to fight back. Why didn't the CFPB protect NBA's customers from the bank's terminations? Again, Bank of America, US Bank, TD Bank, and BMO Harris. By November 23, 2015, all 4 banks had terminated the trust accounts, eliminating the NBA's biweekly program for 135,000 customers. NBA took almost 13 years to create this business, yet it only took 1 day to take this Ohio company down overnight, even when there was no concern of harm regarding customer funds by the CFPB. This event was on the order of a Katrina-level natural disaster or some other terrible event that will always be remembered by those involved. The consequences of the bank's termination resulted in the immediate layoff of almost all of our employees, pink slips being handed out on the Monday of Thanksgiving week. And these were employees who had years of training who were lost not only to NBA but also to these customers who depended upon NBA. Within just a few more months, pretty much everybody was laid off. But only a couple of them remained to assist with what now was a massive legal battle. Truly, in the end, NBA felt that it had been betrayed by the very director, Richard Cordray, who had also been the Ohio Attorney General and whose office had scrutinized and vetted all of NBA's business practices only a few years prior. At this point, please understand how NBA was perceiving things. We felt that CFPB was in bed with the DAs. They already had an agenda regardless of their findings. The agenda was predetermined, not even caring about what the work Richard Cordray had done as Ohio AG in vetting everything NBA did, including our direct mail letters, scripts, software, calculations, everything. Changes desired in marketing materials have already been done. What you may not be aware of is that NBA had always acted proactively to accommodate any concerns that a state or regulator may have had. Even during the Ohio AG process, which was from 2008 to 2010, NBA was proactively making changes before the settlement was officially done. When any state agency raised an issue, NBA would always agree to work through and make agreed changes. And most of the time, we had already made changes beforehand. So too with the CFPB, we wanted to do that. Guessing what might be on the CFPB's mind based on questions and depositions that I received, NBA immediately made changes based on items that were thought to be concerned to CFPB, which we did right away even before they filed their lawsuit. Reading the complaint when it was filed, the lawsuit, NBA again acted proactively and tried to make changes. Another example was at the mediation when the mediator asked about what changes CFPB wanted in the direct mail letter, and a few items were finally discussed. NBA immediately made those changes. So changes to the marketing materials is really not an issue to the resolution of this lawsuit. All in all, NBA has already made changes it thought that the CFPB wanted. CFPB blocks settlement again. Even when we sent a renewed settlement letter on September 28, 2016, CFPB again blocked settlement by acknowledging our prior offer of approximately $2 million, which was all assets, money and assets, on November 17, 2015. So again, CFPB again blocked settlement by acknowledging our prior offer of settlement of $2.9 million on November 17, 2015. But unexpectedly, CFPB countered with its explosive increased demand from $31 million now to over $100 million. The same level as Wells Fargo for creating 1.5 million fraudulent accounts. And here the CFPB still cannot give any justification for their numbers. And again, this amount of money was so crazy because it was so beyond any financial assets that my company or myself had, even a fraction. The logic of this number was to show us that the door was slammed closed to any settlement. And this outrageous response took 5 months, such that when it came on February 24, 2017, the trial was right around the corner in 2 months. And the expensive discovery was virtually completed. CFPB had even tried to delay the trial to deplete our resources, which our contact, who knows Richard Cordray very well, so that's how government operates. They want to deplete your assets so you cannot even make it to court and get due process. That was his comments. And we truly saw, as they tried to extend the trial further and further out, that we were about to run out of money. From our perspective, the facts about these prior settlement discussions demonstrate that in the past, our company has been singled out and the CFPB has abused its power in withholding settlement from us. Our company's history with 40 state licenses and an A rating from the Better Business Bureau shows its ability to work collaboratively with regulators and consumers. We believe that there is only a small group of employees who are involved. Deborah Morris, at CFPB, Deborah Morris, the Deputy Enforcement Director, is one person whose name is throughout, from the beginning to the present. There are others as well. Some objective data, and I'm about done. Here's the objective data. 99.41% of Nationwide customers said they would recommend Nationwide to someone else, and Nationwide had a 97.3% customer satisfaction rate. And the CFPB knew this. Another measure of customer satisfaction involves revocation by consumers of the automated clearinghouse electronic debits from their personal bank accounts. This measure was considered a significant indication of a bad actor in the Operation Choke Point program, as a high number of those revocations by customers to reverse a debit, saying it wasn't authorized or fraudulently or a bad product or service. A high number of those was a red flag. But in Nationwide's case, it indicated the exact opposite, as the number of revocations was extremely low, and all of the banks Nationwide worked with, Bank of America, US Bank, TD Bank, and BMO Harris, were very satisfied with our extremely low number, below industry standards. We were extremely low. One last point. One thing that must be kept in mind in reviewing all this history: NBA's program has been reviewed and analyzed by over 40 states and has been shown to provide the interest savings it claims. Not only state examiners who have come into NBA on site and reviewed whatever they want, but also an independent CPA firm who examined where the funds went and whether the savings were as advertised. This was a CPA firm that was hired, had to be paid, but they were completely independent to come in and examine everything. And they found the program itself to be exactly what it says it is. And even a new attorney that was brought into the case from a district attorney's office in California with John Hubanks to try the DA's retaliatory California state lawsuit against Nationwide has looked everything over, and he said, "I know it's a good product." A new attorney within the DA's office said that to us. Given this truth, why was NBA allowed to be shut down and 135 customers harmed by not allowing them to continue receiving even billions more in scheduled interest savings on top of the over $3 billion already achieved from this good product? February 2019, current financial condition. After it's been since 2013, it's 2019. NBA was shut down in 2015. We've suffered over 100 million in losses, which does not include future losses. NBA employees suffered loss, all being laid off except for a couple. I've sold off and depleted millions, almost everything I have. I have no other resources, no other sources of revenue. Mr. Lipsky, I myself have approximately a month or two of cash reserves left to support my wife and son, and to keep from defaulting on mortgages, the company building, my home, car payments, utilities. I'm on the verge of bankruptcy for what has been proven to be for so little. All items that could have easily been resolved without NBA being shut down and 135,000 customers being harmed. That's all I can think of to say, which I know is a lot. We've tried to get NBA going again, but there's so much damage on the internet that's still out there on the press release, which a lot of that was proven to be false, but it's still out there claiming it because the judge ruled in many areas in our favor, in certain areas with the CFPB, which just had to do with very basic items, of actually items we had already changed before the trial, back when we were proactively trying to figure out what they wanted. And one thing that was very telling, the judge said in his opinion letter, that anything that NBA did, that none of it was intentional to harm somebody. None of it was intentional to harm. That said a lot. So, if I have something more to add, it's very at this point you start to lose, a person can start to lose their will to live. When they've been in a battle for 6 years, and you work so hard for so long to build something to help consumers, those who want the service, nothing's forced on anybody. It's that's it. Thank you for listening. Thank you.